Thank you.
One quick question. Originally, when you established the landfill, which you said was 7980, the land in Charlton, was that owned at that time, or was the land in Charlton purchased later on?
I do not know who had ownership of it in the time of 79 and 78. I do know that SRDP purchased it later in the day, in time.
Thank you. You guys have more questions? You have a lot to digest. Well, I have one question. So you just mentioned that properties have driveways, residential structures, commercial structures in the town have driveways. And even though there are certain rules in the zoning bylaw regarding certain driveways, shared driveways, driveways for different zones, the driveways there, the primary use for that, for that property complies with the zoning in that. The driveway's more of a passive or accessory use. So the primary use of structure already complies. So the passive use would comply with the primary use. If, in your case here with the detention basins, there's no allowed use necessarily for a landfill in Charlton, but the detention basin is somewhat of a passive use for that. And if it's not in the bylaw, it's not necessarily allowed. Wouldn't the detention basin also not be allowed as part of that?
Mr. Lenardo said that if something is not listed in the use regulation schedule, that it's expressly prohibited. Since detention basins and driveways are not listed in that use schedule, I was responding to that point.
Okay.
But that doesn't mean that they're not allowed, just the fact that they're not listed in the use regulation schedule.
Okay, I see what you're saying.
Mr. Chairman, maybe one of the things you might explore with Mr. Poirier, if we assume that there was a large agricultural development on this land, on the land in Southbridge, would the kind of a basin that would be constructed be any different than the basin that we have there now?
Not necessarily,
I think.
but the use would be allowed if it's a.
So the same, you would have the exact same basin, but you would object to it because of what's properly permitted in another town.
The use in the adjoining town is an allowed use
Yes.
in this town, and the fact that incidental or accessory to that primary use in the other town, if it was agricultural use there, then it would be allowed.
And it would be the same basin.
It would be the same basin, and it would be allowed.
But they would have to come to zoning
Why?
because of the use. The use is extended into Charlton. A sheep farm is extended into Charlton. If they have to use it.
His point is,
think I was going to.
Again, Chair, let me speak to that, please. If I may. So oftentimes we deal with conservation decisions, and this has happened in other towns that I work with. The conservation doesn't rule the zoning per se. So there's a determination made by the local zoning enforcement office to whether the use is allowed in the town. If the use is deemed to be allowed either through special permit, variance, or by right, then conservation typically addresses the conservation issues. They're two distinct and different issues. Whether the use is allowed, and then what happens if the use is allowed either by special permit, by right, or by variance, then conservation will comment on runoff, how it affects the wetlands, how we can go into the stormwater system, blah, blah, blah. As zoning wouldn't interpret the conservation, conservation doesn't interpret the zoning. So in the analogy used at driveway is accessory use, it's accessory to the main use of the residence. So if the residence is allowed, the driveway would be allowed. In this case, if the landfill is not allowed in Charlton, which I don't believe it is, in my opinion, from a zoning standpoint, then any associated accessory, needed, whatever you want to call it, catch basins, trap rock, anything associated with the landfill would then not be allowed in Charlton, because the use itself would not be allowed. If the catch basin was just put there, and it had nothing to do with the landfill, it had nothing to do with anything, you just had to put them there from a conservation standpoint, it might be a different conversation. Then the conservation board would act trying to stabilize the land and just not have a washout. If this land in Southbridge had not been developed, there wouldn't have been a need for the catch basins. You've heard that tonight. It's pretty clear that they needed the catch basins as they developed the landfill. So then you look at the use. Conservation, and I can't speak to whether they were ever asked on the use or not. That's, it's a different board, you have to go to them. I don't know if it ever went to your zoning enforcement officer. As I stated in the last meeting, a lot of times this is done on it's complaint driven. Sometimes it's done prior to a complaint. I don't know what the history of this, if it was ever brought to your board prior to this complaint. So hence, the analogies are kind of off a little bit. Just in the same analogy, conservation couldn't authorize a catch basin in the neighboring property if I had my driveway on my property and the conservation said we have to put a catch basin in the neighbor's property. They couldn't allow that. That would be a violation then. And that's akin to what they've done here. So I don't know if that's addressed the conservation issue, but as I tried to point out last week, there are two distinct issues, the use and the conservation. Because conservation gave them authority to put the catch basin in, that doesn't mean the use is allowed. They didn't rule on that. They don't have the authority to do so.
To get back to your point, Mr. Chairman, I think that what we wanted the takeaway to be is that the basin would be the same if it was a farm, if it was a big box, or whatever is there, which is why what our concern is that what's happening in effect is that the board is being asked to make an enforcement decision that really affects a properly functioning and approved and actually extremely closely regulated operation in a neighboring town. And that's, we're not quibbling with anything else. No one's suggesting that a landfill, has been, that this land has been zoned for landfills. We did point out that landfills have existed within the agricultural zone and that Charlton has permitted that to go on. The agricultural zone was set up with an active landfill still within it, and that seemed to be consistent with the purposes, or at least no one complained about it. And all we want to do is to make sure that the board has the facts and has a fuller picture of what's going on here. That, regardless of use, and I don't think we disagree with the fact that you don't need a basin until you develop something, because nature takes its course before then. But once you start to develop, you change the way water is absorbed, and you want to make sure that you protect the environment. This happens, the approved use here, in one instance happens to be a landfill. Don't forget that in the other, with respect to the other basin, there's no influence of the landfill. Essentially, this is water that's in soil, clean, unadulterated soil. And that's what's going on. So I think those are the questions that we wanted to make sure were clarified for you, and we're happy to answer any questions that the board has.
Your question? Bob, Rob, Bill? Attorney Krieger, do you have a comment you want to make?
Anything you can say to us?
I hope it's procedural.
The
That's
first,
what we're told.
first point is procedural. I take it SRDP has finished its presentation, and it has touched on a number of the exhibits in the binder, but not all of them. And if I were the board, I would want to know, are we supposed to look at the others? What are we supposed to make of the others that they haven't mentioned? I don't know if their intention is to mention all of them. Some of them, for example, number 5 says it's a zoning map, but it looks very different than typical zoning map to me, so I don't know if you want to hear anything about the other exhibits, or if you just want to know that you don't have to look at certain ones, but that point I thought should be clarified.
To his point, you had submitted some documentation through our council earlier before the whole hearing started. You want to take a look at this? That was from last week? You wanted us to accept this as part of the record as well, these handouts?
Which are you referring to the motion that we made last week? I thought that had been accepted into the record.
Is that what that is? Oh, okay. Yeah, we talked about that last week.
Yeah, you acted on it.
Yeah, I didn't know that.
I was just referring to the exhibit in the binder.
Right, I know you were, but I mean, she had this sitting on the table, and she's like, right? That's
all.
So the other exhibits in the binder that we didn't necessarily go over, is that something you want us to look at as well? Is that something that you want to go over with us, or just have us read through it?
I think you'll see that the exhibits are, with a couple of exceptions, largely publicly available public records. And they're
Okay.
really to be able to answer questions of the board, but
Okay.
we would submit all of the marked exhibits, 1 through 13, for the use and information of the board, and
Okay.
put them to the record.
Attorney Krieger?
Mr. Chairman, there are a couple of lines of questions that you might want to know the answers to fill out the record to enable you to make a decision. And
I
the
have
question is,
You're going way beyond procedural advice here. This is advocacy advice, so
Okay.
you've taken a position before the
Mr. Chairman, may I be heard without
board.
interruption by counsel?
Yeah,
May I be heard without interruption by SRDP's counsel?
yes.
Thank you. SRDP can paint this however it wants. As I hear the evidence, there are questions that you may want to know the answers to. Whatever the answers are, and whatever you do with the information, I can suggest those questions now, and then you can ask them or not ask them as you choose. SRDP can object if it likes. You can wait until you see what comes out in any public comment or questioning, and I can hold my thoughts until the end, and maybe it'll be moved. Proceed however you want.
With all due respect to Attorney Krieger, I'd rather wait till the end.
No respect or disrespect, however you want to order it.
Yeah, I'd like to let it all come out first, and then if there's any comments, whatever. You're not at all making any representation that either one of the detention basins is considered a structure or anything like that, correct? Mr. Poirier had mentioned that we built this, we moved this. You're not making that contention at all as part of the appeal, right?
It's not part of the appeal, Mr. Chairman. It was It was, we've offered what we have offered with respect to that issue in the event that the board thought it saw fit to head down the route of a variance rather than just appealing the cease and desist order as a means of resolving the case.
Okay. I think in the original appeal, I think you did mention that somewhat, right? Just before you talk about
For that purpose, yeah.
construction, and so it kind of brought me back to that a little bit. You don't consider a structure, a detention basin a structure all three, Mr. Poirier?
He may not, if I could, Mr. Chairman, he may, I don't know if he knows what a structure is with respect to the zoning law versus a structure, but that's what I would ask him those questions.
Yeah, so is it?
That's what you're getting at, is the structure of it,
Well, I
recognized by
don't-
zoning.
Yeah, and so in our definition section, it doesn't really, it says any combination of materials assembled at a fixed location requiring attachment to the land for pilings, footings, foundations, and the like. Give support or shelter, provide union for use such as a building, bridge, trestle, framework, tank, stadium.
Mr. Chairman, may I make a suggestion?
Yep.
Rather than engage with the engineer about the zoning definition, which, as Mr. Kirsch pointed out, he may not be prepared to do, understandably, it may be productive on this issue just to ask, what do these detention basins look like? What are they made of? How are they built? And then you'll make the judgment whether they're a structure or not.
Well, they're not making that argument anyways. I don't think they're going to follow it any further.
In what they submitted tonight, it wasn't clear, but if you're clear on that they're not arguing.
I'm fine with that.
Okay.
Gentlemen, do you have any more questions? Mr. Leonardo?
Sorry, Mr. Chair. Again, a point of clarification, they actually did make that contention, and in my rebuttal, I answered that. So I don't believe it to be a structure, because they actually claimed that they were grandfathered because it was a structure built prior to 10 years from the date.
If it's considered a structure, it was constructed more than 10 years.
It gets very tricky on this, under the new 40A. There is some grandfather for a structure that's in excess of 10 years if no action has been taken.
Yes.
However, that doesn't specifically go to the use of the structure.
No, it doesn't.
Nor does it, again, in my rebuttal, I answer the statement about the structure. I think the council is paraphrasing your definition, meaning Charlton's definition of the structure. I clearly don't think it meets that criteria. It's not used for human occupancy in any way. They cite pools and the like. Those are humans usually dive into pools. I don't suspect that most people are using a catch basin like a pool. I don't see how they can make a contention that the catch basin rises to the level of the structure. So I would contend it's not a structure.
Okay,
Just as a point of clarification.
I appreciate it. Do you want to hear from anybody else in the audience at this point? I don't think we have any more questions at this time. So we'll hear from members of the audience. Is there any interested parties, abutters that'd like to speak?
I'm not an abutter. Charlton resident.
Come to the microphone, state your name and your address for the record.
My name is Bob Brunel. I live at 261 Brookfield Road in Charlton. I reviewed this material over the weekend, tried to simplify it so that even I could understand it. And I have 4 points that I'd like to share with the board. Firstly, I think the real issue here is a violation of Charlton bylaws. With all due respect, you're not the zoning board, the DEP zoning board of appeals. You're not the conservation zoning board of appeals, nor the board of health zoning board of appeals, or the planning board of appeals. You have enough on your plate. If the Zoning Board of Appeals to address zoning issues. Secondly, a lot has been said about the flow of water from the project into Charlton land. And a lot has been said about separating the flow of the water from the project. The fact is, if SRDP had not constructed the landfill on the border of Charlton land, we would not be here today. The natural water flow would not have been changed by SRDP to flow directly onto Charlton land. Thirdly, the appellate has tried to negate the Charlton bylaw by stating that Charlton bylaws were voted in after the landfill was constructed. In my opinion, that has no basis. The bylaw violation and the violation of land use on Charlton agriculturally zoned district happened in 2005 and in 2014. Lastly, the appellate tries to make a case that if the land use is not specifically prohibited, it is allowed. No. If a land use is not specifically stated, it is not allowed. The solid waste use is neither listed in the agricultural district nor in any other district, therefore it is not an allowed use. If the board approves this appeal, you open the door to other agricultural zone districts that are not specifically identified by the Charlton bylaws. For example, what if a cement plant was constructed in Southbridge and the natural flow of water was altered to flow directly onto agriculturally zoned land in Charlton? Would that be acceptable? Of course not. As Mr. Lenardi has succinctly pointed out in section 200-3.2A, premises shall be used only as set forth in the use regulation schedule, except exempted by 200-3.4 or by statute. And neither of those apply in this case. It is clear that SRDP violated the Charlton bylaw and should honor the cease and desist order. I thank the board for your time.
Thanks, appreciate it.
Thank you.
Is anybody else, any other abutters, interested parties? Ma'am?
Good evening, I'm not an interested party, but my name is Kirsty Pesci, and I'm a staff attorney at Conservation Law Foundation. I live in Sturbridge, Massachusetts, and I've been following this landfill case rather closely for many years. And I'm also as I said, I'm an attorney. I worked at Nixon Peabody for about 7 years, and I have a lot of experience in zoning matters and other municipal law. I was also at Coleman and Page when I was at law school. So I would like, if I could, to clarify some of the history around this site and give you some background just to make this morass a little bit more straightforward. Okay, good. As Mr. Leonardo has said repeatedly, the issue is whether the landfill is an allowed use and whether those basins, which are in Charlton, are an appurtenant use to the landfill, part of the landfill, and therefore would be allowed if they, if the zoning is proper in Charlton. I'm not going to go into the zoning. You've already heard from him, and he's more of an expert in this area than I could be, and absolutely correct. It's an appurtenant use. Landfills are not allowed in this district in Charlton. Therefore, that's not allowed. To give you some clarity on the fact that basins are part of a landfill, another area of law where this has been discussed and considered is whether a basin needs to be site assigned for purposes of the Board of Health. is a basin part of a landfill, so therefore needs to be site assigned. And if I could give you a letter from the DEP, the Department of Environmental Protection, dated June 12, 1991, in which they were asked that question. There are basins and other pertinent, not structures, but pertinent pieces of equipment and different things, part of a landfill, and they go into that in detail. And what they say very specifically is that stormwater basins like this one, as well as leachate storage facilities, tanks or lagoons, stormwater drainage systems, pump stations, stormwater drainage swales, stormwater sedimentation ponds, the exterior slide slopes of landfill containment berms, the limit of the landfill's cover. So not the refuse, but the all those other pieces that are necessary for a landfill to work must be on site assigned land because they're part of the landfill. They are an appurtenance, as we've been discussing. So if I could give you a copy of this letter, just to submit it for your review. If there are enough copies there to also give to SRDP/myself.
I make a motion to accept it. Or make a motion?
I want to see what Mr. Kirsch has to say. Before I make a motion, how many copies are there?
And again, the point here
I think
is,
I can respond to the letters. That is in fact a letter that was issued by the department for whatever a letter is worth. But also keep in mind that the department has said that these basins did not need site assignment, that they are okay where they are. Ms. Pecci has already raised this objection in other litigation, and it's been rejected by DEP, and it's been rejected by the state Supreme Judicial Court.
actually, what the DEP said is the DEP does not tell a conservation commission, excuse me, a board of health, whether they ask for a site assignment. So the DEP's position is we consider these pieces of equipment, in this case a basin, as part of a landfill, but we're not going to tell a board of health whether they have to have a site assignment hearing or not. So, and to be specific, when I asked, is this part of a landfill or not, this is a letter that I was sent by Amber Lynn Blackman from the DEP years ago. So, just to be perfectly clear. Now, another thing that I think is really important in understanding this site's history, the landfill, yes, was site assigned in 1979, but that was a portion of the landfill that was in what was then Southbridge. If you remember, the town line changed in the 1990s. And the reason the town line changed is because Southbridge wanted to make the second half of this landfill, they wanted to develop it. So the first half of it, that 20 acres, was site assigned in 1979. Then the town line was changed to include the area that's the second half of the landfill where these basins abut now. That wasn't in Southbridge at that time. So there's no question that in the 1990s, when this second half of the landfill was site assigned, and when the town line was actually moved, before that time, these basins had not been built. So just to put that to rest, that's what happened. Now, also, I think it's very important that you understand, and for any of the points I'm making, I'm happy to provide documentation. But I think it's very important to understand as well that in the early 2000s, if you'll remember, the landfill was a mess before Casella took over. When Wood Recycling was handling it, we had a lot of odor problems, and there was a huge problem with the wetlands. If you'll remember also, just to remind you, this was originally a local MSW, meaning municipal solid waste landfill, and then in the 90s, Southbridge decided to expand it to include processing of construction and demolition materials and to take in more construction and demolition material. And so as that landfill expanded, that's when they started having these problems. There was a fire there for over a week. This is all before Casella took over. And the wetlands around the landfill were negatively impacted by the mismanagement of the landfill. At that time, Casella came in and took over the operation of the landfill. So that first basin was due to a court order that also included a hefty fine. We're talking about, let me see, make sure we got my numbers exactly right. So the first judgment, I believe, was $400,000, and they could add another $150,000 in 2005. And that was the agreement that the court report made and the DEP made with Casella because they were going to come in and operate the landfill more professionally. Now, since 2004, when Casella took over, one of the reasons that there was a soil spill, in a huge soil slide, landslide of soil into the wetlands, which necessitated that second court order in 2014, is because Casella, since 2004, has been taking huge amounts of contaminated soil and using that for daily cover and weekly cover. Before 2004, when wood recycling was operated, they didn't take any contaminated soil to use for daily cover and weekly cover. In 2004, when Casella took over, they took 12,671 tons of contaminated soil. In 2006, they took over 95,000 tons. And those numbers continue to be large. 2012, 54,000 tons. 2014, 54,000 tons. 2015, 82,000 tons of contaminated soil. So according to the DEP, this site has plenty of natural soil. The soil that you see stockpiled around this landfill is when they dig up the bathtub structure and create those cells. The DEP has said many times there's a lot of clean soil, so they don't need to take contaminated soil like this or ash if they don't want to, but it's a cash crop for them. It's how they make money. They get paid for the ton.
How is it built relative to this appeal today in Charlotte?
I'm sorry?
How is all this background information built?
So in 2014, Salford's landfill to pay $220,000 to settle wetlands damage claims from massive soil landslide. This is a press release from the AG's office. And so in other words, what happened is, over time, granted, what happened before 2004 is not Casella's fault, but we all know that wood recycling mismanaged the site and was impacting the wetlands negatively. But then, 2004 to 2014, they were taking tens of thousands of tons of contaminated soil, ash, and they used that for their daily cover and weekly cover.
You're saying it's on Charlton land? Is that what you're
So what I'm saying is that the reason that there was a huge landslide in 2014 is because that clean soil was chosen to be put there, because instead of using that, yes,
Okay.
instead of using, well, no, on the edge of it, and then it went into the wetlands. And so instead of using, so instead of using that every day to build the landfill, instead they brought in contaminated soil and ash. And if you look at these different reports, it's a huge amount of soil. So this is a
huge
problem.
amount of soil in Charlton.
Huge amount of soil that fell into Charlton.
Okay, just stay with Charlton, please.
But it fell into the Charlton wetlands, and this basin was created to manage the soil runoff into Charlton, the basins in Charlton.
So what you're saying is there was a violation, DEP, and through litigation, they were determined that they had to put these basins in to fix that problem, correct?
Correct.
Okay.
And I'm saying that while I understand that basins are needed to run a landfill to deal with stormwater runoff, much of the problem here has been brought about by Casella's own greed, because they're going to get paid per ton for this contaminated soil, for this ash. Just so you understand why there is a huge soil pile that then is going into wetlands. It's not an accident.
We got that idea.
Yeah, so
we got the commercial idea.
yeah, excellent. And so I'm perfectly happy to, all the reports that document this, and so you can take a look at them if you're interested. I didn't bring a big pile of documents today because I think you guys are buried enough. And I think Mr. Lenardo's done a fantastic job of outlining the zoning issue for you, so I don't need to go into that. But I just wanted to let you know, this isn't something that happened by accident. This is a choice that Casella's made in how they operate their landfill. Any questions or anything else?
They're not using that soil containment pile at all for the landfill right now then?
I don't know if they use some of it, but I do know that in 2015 they took 82,000 tons of contaminated soil, and that's not including the ash. One year they took more soils and sweepings and ash than they did waste. So, it's a lot of material is my point. And I think that goes to how they're running the facility. You wouldn't have a soil slide into the wetlands if you didn't have tons of literally tons of stockpiled soil there.
We're not interested in how we're interested in how we're running it into Charlton.
That is the most important point. The basins are in Charlton and they're not zoned. So, but the rest of this is kind of background color. But I wanted to make you aware. Okay? Thank you.
Mr. Chairman, if I could just have a remark.
Yes, absolutely.
I never thought I'd find myself in a position saying this, but I appreciate Ms. Pecci clarifying the record, as we had tried to, that Mr. Lombardo's impression that one of those basins is associated with the landfill rather than the soil pile was simply wrong. And it is associated with an inert, clean soil pile. I just wanted to make sure that the point wasn't lost. We so rarely get a chance to agree.
Someone want to make a motion to accept this?
I'll make a motion. I'll make a motion to accept this.
All in favor, say aye. Aye. Yep. This is the motion that was made last week regarding Anderson Krieger. Mr. Leonardo, one of the members of the board has a question for you.
I assume you, my name is Bob Howard. I assume that you heard the plaintiff make a number of statements, and then the other person on that team over there would say, is that statement correct? And the answer was always no. I don't know that you would like to give you an opportunity to not to give no validity to what they said.
Well,
I mean, if I'm just saying, paraphrasing, I'm saying if it was me, I wouldn't like it. I would have to defend myself.
well, I take no offense.
I would like, excuse me, I would like you to tell me, tell this board, that these statements that were made, can you diffuse those from the standpoint of no, no, no?
Well, I think I have as you've gone along, but if I haven't, I'll
Well, I
try.
can't remember, I'm sorry, I
That's
can't
okay.
remember all those questions. And then have the person that they were asking of this on that.
Well, I'll
All
be
I
honest.
know it was negative. Every single one of their questions I can't remember her name. Every single question was answered no, not in the affirmative.
Well, I'll make a couple comments if I may.
Please.
So, first of all, in most of the associations I've had, I've never seen it run as a deposition similar to what's been done here. It's not normally a presentation done as that. You're not question and answer type back and forth. This was set up more like a court. So I'm not really sure how that's done. I've never seen that done in a zoning meeting, and I'm on a zoning board. I've been on a
Neither
zoning
have
board.
I.
I've been on a zoning board for many years. I take no offense from the plan of trying to, degrade my interpretation. It's strictly that. Let me back up, because a lot of things presented as saying that I was factually incorrect. My interpretation is just that. It's a zoning interpretation. They can argue that my opinion is incorrect, but I don't believe that most of the things they argue, you're saying that I was factually correct, that's factually correct. They tonight admitted that the Southbridge land was manipulated and it was developed. That to itself is a use. We're not arguing to whether it's a structure or not a structure, I don't believe. I think I've looked, my opinion is not a structure, but the use of the land is the development of the land. They all admitted that it is a development of the land. I don't think they're arguing that they haven't developed the land. What they haven't talked about is the topography. They greatly altered the topography in Southbridge, and that goes to my point, is that I think if there was no alteration of the topography in Southbridge near the Charlton line, we wouldn't be having this discussion. So in my opinion, the development of the land goes directly to why I made the interpretation I made, to why the catch basins were required. You can argue that it was clean runoff, it was filthy runoff. I don't have the expertise to argue that, nor was it in my opinion. What I was saying is that they altered the land and they developed it such that the catch basins were required as part of the landfill use. Now, they also said tonight that they don't need the stormwater catch basins. Then it's pretty simple. They can adhere to the cease and desist and eliminate the catch basins. And we can all go home happy. That's part of the, that's what I heard tonight too. But I disagree with most of the fact they said I was factually correct with all that. I don't think anything tonight presented that really opposed that. Because they haven't said they didn't alter the land, they're not making that claim. Mrs. Markin specifically said, and I quote, that the catch basin is required for the landfill to operate. She was asked that by one of the board members, and that's what her response was. So they made their case for me, as far as I'm concerned. So I don't know what else to say. As I said, I don't begrudge them trying to attack me in many ways. I just never seen it done in this particular manner. I don't know if that goes to.
I just wanted you to get a chance to reflect on what they were purported to. And I think I'm satisfied with what you just told me.
So, Ms. Pesci had just mentioned about the soil, I'm sorry,
The Northern Soil Stockpile.
the northern soil, I don't know why I can't remember that.
That's okay.
Northern soil stockpile. If they're not using that as part of the landfill at all, they're taking it off of Southbridge and dumping it, and it's not being used in any way to be capped back onto the landfill, would you still consider that as part of an incidental use of the landfill?
But it depends on what they're doing with the soil. If it's just repositioning on the land, it goes back to what the use is, but certainly if they're selling it, then you have a quarrying issue.
But you're looking at a completely different use at that point, don't you think?
Absolutely.
Yeah.
And I don't know if that's allowed in the bylaw. That wasn't explicitly asked in the zoning complaint, but that opens up a whole other realm of possible violations.
I was not saying they weren't using any of it, I can't speak to that. I'm just explaining
No,
why there's so much on the facility, at
Right.
the facility.
Yeah,
I don't want to break that representation anyway.
I was led to believe that the stockpiling was also used for coverage of the landfill, but I may have been misdirected on that. I was present with two of the landfill employees at the time of my visit. I didn't just go out there unannounced, just so you also know that typically I wouldn't do that. I was allowed to go onto the landfill site. I was accompanied by Charlton employees, but I was also accompanied by two individuals from the landfill. But you raise an interesting question, is that the stockpiling in itself.
Is that an incidental use of the landfill if then it's not landfill purposes.
Well, I think it goes beyond that. I think-
But I don't think that's, I'm sorry, go ahead.
No, my apologies. Part of, as I understand it, and I'll refer back to it as was kind of spoken to in my cease and desist, there's a tub effect. I don't think anybody's debating that. Correct me if I'm wrong, but they altered the land and topography for the landfill to continue to operate. So they continue to fill in that tub, if you will. And that's what I was referring to in my documentation, is that my understanding is that the land, they show the edge of the Charlton land being the landfill. So the refuge actually stops some feet before Charlton land. But they actually build up the side of that tub, if you will. They put in a water retention material to line it. And that was explained to me by landfill personnel. That's not my words. They explained it to me, and I saw that.
The tub effect that you're talking about is the actual landfill in Southbridge. You're talking the runoff from that, or are you talking just the fact that the land in the Charlton portion or just on the line is altered to the point where it creates that tub effect? Is that what you're saying?
Yes, that is exactly what I'm saying. And some of that is due to the stockpiling. Again, as it was explained to me, is that there's been different materials moved on and about Charlton land. That's stockpiling effect, if you will.
Mr. Porter, would you agree with that not so much the fact that where the landfill is in itself, but just the fact that the alteration of the topography as a result of other parts of the landfill, it has changed the landscape that would affect the Charlton portion of the land? So I think what he's saying is, this is what I understand it is, it's not the landfill itself, the tub effect of the landfill, that just through the natural development of the overall project has created a tub effect for those detention basins. That's what you're saying, right? That's why I understand what you're
That's
saying.
how it was explained to me, yes.
No, I'd say the development that has taken place in Southbridge has caused stormwater to flow into Charlton that was previously flowing there. But that's as far as I would go.
Okay. Yeah, I know. We only have like 10, 14 minutes left. Well, Janet has to kick us out.
Mr. Chairman, if I could, I think that the discussion has been kind of helpful in illuminating some of the issues. We're not disputing that the land in Southbridge was developed. We agree, or that it wasn't developed for a landfill. We agree. There's a landfill that was developed, and that if it is development in our society that requires stormwater basins, we put them in because we have development. But the point that we wanted to make, and I hope the board understands this, is the amount of water that's entering Charlton is actually less than it would have been without the landfill. So that there is still water coming in. And that the stormwater basins that are built would be the same regardless of the use that was in effect on the land that was flowing there. So whether it was a skyscraper or a parking lot or a big box store or a landfill, you'd have the exact same basin. And that you actually have these basins, the exact same function at other locations in Charlton, including, you will see in the materials that we gave you, in areas that are zoned for agricultural purposes. So we simply want the board to have all the information in front of it. And this has been, this facility has always been a controversial one. I can't take that, we're not going to be able to change that. All we're asking is that the board look with a clear set of eyes at what's really going on here. We're talking about flow that would occur regardless in terms of the water. So there's no additional water flowing into Charlton. And the water that reaches Charlton wetlands is actually doing so in a way that is far more beneficial environmentally than it would be if these basins are not in place. But we're happy to answer more questions.
Yeah, I think we've taken a lot of information this evening. I think I need a little time to digest them.
You want to have another meeting on this?
Yeah, I'm not ready to,
Okay.
yeah, I mean, I don't know. What? Yeah. Yeah, I'd like to look at what's been presented this evening from all the parties, and then maybe, I don't know, if maybe have a few more, what, say that again?
Sit back to college.
Hey, you'll be an engineer by the time we read through all this.
Have our exhibits been accepted? I thought they were. But
I thought we accepted this last week. We accepted the binder last week, I thought,
Okay.
yeah. So, the only thing, I put the motion into the record regarding the initial conversation we had with regard to council. So that's the only other thing that we had. And, Ms. Petchy?
And we did put the reply in there too.
Yes, I already did that as well.
If you're extending the meeting, would people have the opportunity to comment at the next meeting?
So as long as the board is okay, I would,
Yeah, we're not closing the meeting.
yeah. I'm not ready to. I mean, are you? You might give more, I might read through this and have more questions.
Okay.
That's it.
Yeah. Yeah. And I don't think that it will meet again next week, that we're gonna take 2 hours worth of comments. It would just be a little bit, at this point, this will be our third meeting. We'll probably close that, the open hearing portion and deliberate and possibly make a decision next week. Because we all want you to come back to Charlton again one more time.
So 25th.
Attorney Krieger?
Can I just ask that you confirm what's in the record, or what you think is already in? There's the binder,
Yes.
there's the motion regarding council,
Yes,
there's Mr. Leonardo's January 30 letter,
yes,
there's SRDP's reply that came in tonight,
yes,
there is Ms. Petchy's, the DEP letter,
yes.
and there might be one more thing. Is that it? Is anybody?
I think that's it.
The notice of
No, it's the appeal itself, right?
Yeah, the original.
Okay. Just, if anybody thinks anything else is in the record or should be in the record, I just thought I wanted to list them.
Yeah, we're gonna do the minutes from the last meeting. Oh, this is from, this is the April 4th meeting. We didn't do this last week. You guys sent a copy of this?
Going to schedule a date for next meeting.
Yeah, next Tuesday, April 25th,
April 25th.
7 PM.
Okay.
We're gonna do it, I think we have to do it here because the library is taken. Someone's already booked the library, so we have to come back here.
What's the big deal with the library?
Well, the only reason why we did this is because we thought there might be a lot of people that may want to
The
come.
library's big, too.
Right, but we can't use the library because it's already booked by somebody else.
What's the difference? Because it's closer to your problem.
No, it's just not as big, that's all. It doesn't really make any difference.
Okay, I just didn't get it.
No, I just thought it might be because it's not as big as this.
Okay.
Yeah. Someone make a motion to accept the minutes?
Make a motion.
All in favor, say aye.
Aye.
Someone will make a motion to recess until April 25th at 7 PM at the middle school.
Yeah, I'll make a motion.
Is there a second?
Second.
All in favor? Aye. Carries. Yeah, but-